This second video will consider some of the legal issues raised by Mrs. Williams in her case study. We see here what looks like a fairly complex family history. Michael is a person who has a background in alcoholism. He is, however, the good and diligent son it appears to be. The daughter we don't know much about in terms of her history, but we know that she doesn't have a close relationship either with Michael, and we're not really sure about her relationship with her mother. She certainly looks to be somewhat officious and swooping in. Mind you, that may be based on experience with her brother, and indeed we're not sure about her relationship with her mother. Mary herself, Mrs. Williams, seems to be very independent, and she's managing by herself. She lives at place. We know that she has a history of blood sugar issues and urinary tract infections. So when we're looking at the questions about how the family is embedded, we are initially raising, if you're going to be looking at your counterpoint charting sheet, you will be writing down some of those basic case histories and some of the concerns that you may have. We don't have any validation that she slipped and fell. At this point, it doesn't seem controverted, but we may want to make sure that she wasn't pushed in some way. And when we come into the hospital, that's where really we see a number of the legal issues unfolding. But let's first go back to the question of the emergency worker. We have her being taken to hospital. We don't have any understanding whether or not she provided consent to the emergency medical services to do so. Does the emergency medical services group need to get consent? At this case, they don't. So she is covered by the exception to the law of consent, which allows EMS workers to take her. Now, there's no tag or note on her which is saying very specifically that she doesn't want that. For instance, if she was a Jehovah's Witness and had a necklace or bracelet saying no blood transfusions, and it was easily seen, the emergency group should not do those things to her. We don't have any evidence of that. So we have her being scooped up by EMS, and they're covered through the exception of healthcare consent, which allows emergency workers to treat without consent. Upon admission, we're seeing a number of different legal issues play out. So we see the doctor asking Michael for medical consent to treat Mary. Now, I'm not going to talk specifically about the law in New Brunswick at this point, but I'm going to talk more broadly about the key principles across the different jurisdictions. Now, the doctor, we hope, has first tried to get consent from Mary. We don't know that, so that's an important question. We know that Mary is upset. We know that she may not be making good sense, but we don't know whether or not she was able to understand and appreciate that she may need surgery. In this case, a broken hip will, I think, provide a strong impulse for Mary to be able to give consent for treatment. So we're not looking at a very complex level of consent, such as managing investments and so forth. But we'll assume in this case that the doctor did try to get consent from Mary, and then upon not being able to do so, went further. Now, we see here a bit of a conflation around who to get consent from, and that's the reason why we did the recap on the box, the square with capable person, you make your own decision, and we're, in this case, hoping that that was tried first, and then over to an incapable person and a substitute. So the doctor should have, I hope, made sure that there was not a court-appointed guardian. In this case, there doesn't seem to be any reason why there would be a court-appointed guardian. So quickly you'd move down to a power of attorney for health and personal care type decisions, which is again called different things in different jurisdictions. In BC, it would be a representation agreement. In Ontario, it's power of attorney for personal care. In Nova Scotia, you're looking at health directives and so forth. But you're going to be looking for a document which appoints somebody else to make your decisions. Now, we don't know quite if the doctor asked that. So we see that the hospital staff started asking Michael if he had this power of attorney. But that's the hospital staff, not the doctor. So it's unclear whether the doctor discharged his obligations to do so, and I'm saying his, I'm making him masculine for the purposes of this case study. So that's a little dodgy. In this case, we're assuming that he did not ask, but that assumed Michael was a substitute decision maker pursuant to a default list or a next of kin type statute. Now, New Brunswick is actually one of the jurisdictions where there is not an evident list. But if we put them in, say, British Columbia or Saskatchewan or Manitoba or Ontario, that would be the case. Now, in Alberta or New Brunswick, there's not going to be that default list. So that's one of the reasons that I wanted to make sure we put the case study in a jurisdiction which does not necessarily have a default list. But as I say, in this case, he goes to Michael for some kind of medical consent to treatment. It's a little unclear on what basis. Michael gives it, and I think that's quite common in the case, and she's going to be taken to surgery. Now, we have here a lack of clarity around the hospital staff and their role. So the hospital staff starts asking Michael if he's got power of attorney for medical and financial, and he says yes. But we see later on that a new power of attorney is being executed. So we don't know whether or not he had a previous one or whether he was actually lying or if he didn't know if he had one whatsoever. But it's a bit dodgy to see. We have no proof for the hospital staff that he does have power of attorney. So it's completely unclear. Indeed, if there was some type of power of attorney document, it may be Susan, or it may be a neighbor, or there may not be one whatsoever. So there is a failure on the part of the hospital staff to get the appropriate documentation. The surgery is successful, but the doctor is worried about her mental capacity, and in this case he does an MMSE. Now we know that there's nothing wrong with doing tests like the mini mental status exam, but they are only snapshots and they are not determinative. So the doctor, if he is using this MMSE score as a determination of mental capacity, is incorrect. If he is using it as part of a much broader analysis of her capacity, that's a different issue. But one of the concerns with this case is that it looks like a determination of incapacity is either being made by assumption or a bit of a rubber stamp. We know that she has just had surgery, so there's going to be post-operative perhaps challenges around her capacity pursuant to delirium and so forth. And we know also that she's prone to urinary tract infections, both of which can assume capacity. Doing an MMSE post-surgery is probably quite improper. We'll continue on in our next video.